A whistleblower is a person that discloses any breach or violation of a national or European legislation or reports on any misconduct in this regard. The European Commission deemed it very important to protect such individuals against retaliation. It has therefore adopted a EU directive in 2019 that has now been transposed into our national Belgian legal order at the end of 2022. Since the start of 2023, a lot of these obligations apply to companies within the private sector, but also organizations in the public sector. The obligations are, for example, to implement measures to protect whistleblowers against retaliation and to set up an internal whistleblowing mechanism.
Any company with at least 50 employees on average is legally obliged to set up an internal whistleblowing channel. With the exception of companies that fall under the scope of financial and anti-money laundering legislation, these companies do need to set up an internal whistleblowing channel irrespective of the number of employees. But even if companies are not legally obliged to set up an internal whistleblowing channel, it is key to be aware of the existence of this legislation, because even if there is no internal whistleblowing channel available, whistleblowers or potential whistleblowers may still report any issues externally through an external whistleblowing channel or by public disclosure.
For the past few months, I have been diving into the Whistleblowing Protection Directive. The European Directive foresees a general protection for all whistleblowers, irrespective of the fact that they work in the private company or in a public institution. On a national level, however, this resulted in different types of legislation. We have 2 federal laws, one for the private sector and one for the public sector. But of course, also the regions are competent to implement legislation for their regional institutions. So it is very important for your organization to check the right legislation that applies to you.
Unlawful activities can occur in any organization, irrespective of their size and in whatever form. And it is extremely important for companies to be made aware of such issues at an early stage, to be able to take action soon and to avoid any further escalation. Therefore, the better an internal whistleblowing channel and an internal whistleblowing policy is organized, the more inclined a whistleblower will be to report the issue internally, allowing the company to keep control of the investigation and of the remedies that need to be taken to address the issue. Whistleblowing should therefore not only be seen as an additional compliance obligation for companies, but can also be seen as an opportunity.
The whistleblower legislation is not a standalone act. It may interact with other obligations you can have within your company. First of all, we think about GDPR. In the context of a whistleblower mechanism, you may process personal data. This should of course be in compliance with GDPR obligations. So make sure, for example, to update your privacy policy to also cover any processing in the context of whistleblowing. Second of all, in the context of conducting any investigations following a whistleblowing report, you may want to monitor or access email communication and/or use camera footage. Be aware that specific legislation may apply, and you may also want to update your policies in this regard.